The use of wiretaps by the NSA without a warrant may be headed to the United States Supreme Court. For the first time, the Department of Justice has notified a criminal defendant that evidence being used against him came from a warrantless wiretap. Arise News legal correspondent Seema Iyer joins us today to talk about this and some other cases that are interesting that are making their way through the legal system. Hey, Seema.
I should have brought my glasses that say stop listening. And then we could have really rolled with this story.
Indeed. So since we talked about this, let's start with this warrantless wiretap. Okay, so this is the first time that a person has been notified that the evidence against them came from a warrantless wiretap. So how is it? Let's start with how the government is allowed to do this.
Well, this falls under the Foreign Intelligence Services Amendment Act, FISA, as I know it. And the amendment, specifically referring to 2008, that allows for electronic surveillance when it involves foreign countries. So this is on the federal level. This is very different than the state level. So in this case specifically, we're talking about the federal level, we're talking about foreign countries, and specifically this notification involved notification when the suspect was engaged in international terrorism. And that's part of the FISA.
Okay, and then explain to me further then why the notification is the issue.
Because, Debbie, if you don't know where the evidence is coming from against you, so in this specific case, this guy gets arrested, terrorism charges, and he's going to court, but he's never notified about where the evidence came from. If you are not notified, then how can you challenge that evidence, right?
Mm-hmm. Ah, okay.
So that's why the notification is so important.
Okay, got it, got it. Now, all wiretaps are not warrantless, are they?
Exactly. So in the state level, wiretaps, and most of the viewers know, the show The Wire, or they've heard of wiretaps, and what happens is the police officer and a prosecutor, or let's say there's documentary evidence, all of that goes in front of a judge. And a judge reviews that, or a judge speaks to the officer and swears that person in, and then says, you know what, there's enough here, I'm going to sign a warrant and allow you to listen in or take emails from, and basically those are warrants attached to the wiretap. So and those notifications always given. So it's very different when you're talking about domestic relations and when you're talking about international relations, which has clearly been the scope now of the conversation in the news, whether we're talking about Angela Merkel or we're talking about here in the United States. It involves the foreign service aspect of the act.
I got it. Do you think this will make its way to be reviewed then by the Supreme Court?
I do, and here's why. Before, there have been a few cases in front of the Supreme Court. Before, the trouble was the defendant was unable to say that he had no proof, right? Because he had no notice. So now everything has changed. If I have notice that you have a wiretap involving me, then I know I'm a target and I can produce that in court, and that gives you standing to argue the case.
Okay, so interesting to see
very,
how that
very interesting.
And this is being heard where right now?
This case involves this is in D.C., I believe. I have to check.
I'm sorry,
that.
I came out of left field to ask you that.
Not at all. But yeah, this case, and I do have to check that or ask your executive producer because he knows everything.
He usually has said it in my ear by now, so that means he doesn't know either.
This was D.C. This was D.C. because it involved the Solicitor General.
The Solicitor General.
Yeah, Varela. He was the first person who gave the notification.
All right, and our executive producer says in Denver. The case was in Denver.
Denver.
Okay.
Thank you, Dick Jefferson.
Yes, thank you, Dick Jefferson, in my ear, talking to me all the time. Okay, let's move on to this other case that's very controversial. It's happened at a few other states, and that is this the case about the injunction against clinics that provide abortions in Texas.
Sure.
So let's set up what the issue is first, and because there was an emergency hearing, is that the right way to say it today?
So today was the emergency appeal.
Emergency appeal.
Right. So yesterday, the federal judge in Texas, she made two rulings. One part of their abortion law was unconstitutional, and another part she made revisions, shall we say. The unconstitutional part, she said that when you dictate that doctors have to have hospital privileges within the area surrounding the clinic, that is unduly burdensome.
And it was 30 miles, within 30 miles.
Within 30 miles. And they're saying that, and the judge said it was unconstitutional, and specifically that was brought by 11 clinics and doctors, and saying that this was unduly burdensome. And these clinics were actually in danger of having to shut down. So it really was interfering with a woman's right to have an abortion, which is not allowed by the Constitution.
Right, and so in this case, because of this law that was about to be enacted, then there were a large number of clinics that did provide abortions where the doctors there did not have hospital privileges right. within that 30-mile radius, that were going to have to stop giving the services. And then the judge ruled that that was unconstitutional, and they were able to stay open. However, there was this, as you called it, this emergency.
So today, because of this doctor having hospital privileges is such an integral part of the law, that the Texas Attorney General today, or last night, filed this emergency appeal, and the decision, or at least some type of notice or extension, should have come down today by 5 o'clock Texas time, which it hasn't, as far as we know when we started this segment.
To our knowledge, it has not come down yet.
And that specifically was the doctor part.
Well, let me ask you this question about that. The Attorney General asked for this ruling by the end of the day. Is the judge under any onus to have to give that ruling by the end of the day?
No, the judge is in the Supreme Court, and there's so many times that we've been through this, that we are on here together and think that one decision is going to come out, and then it's a judge. The judge is going to say, give me a week, give me a month. I'm the judge, so no.
Okay. All right. So as I understand it, there were other states that have had these sort of similar restrictions, or tried to put these similar restrictions
right.
On the books. How is this one in Texas different than those others?
Well, specifically, the medical abortion part was a little bit different, and it was just an extra hurdle in this case. The judge said, in essence, okay, this is, when it comes to abortion, we're always weighing these two issues. Is it unduly burdensome, or does it protect the life of the fetus and the mother, right? So this was the issue of the medical abortions, medication abortions. And the doctors in Texas are saying, like many doctors across this country, are saying some methods are so antiquated, so we need to get rid of them and allow the woman to take medicine at home to have that abortion. So what the judge in Texas did, she said, okay, let's take it by a case-by-case basis. If it is unduly burdensome to the woman, but it protects the life and the health of the fetus and the mother, we have to decide based on those things.
Okay, all right. Let's talk about one other case, and this has to do with, it was all over the news, I know people will remember, but review then this British voicemail hacking or phone hacking case.
Right, so this is from 2011, and this is involving Rupert Murdoch's actually, it's a total of 30 defendants, but the two main aides, his senior aides, and not only were they senior aides of Rupert Murdoch, but they were associates of Prime Minister David Cameron. So this got an incredible amount of attention back then in 2011. And now it's finally going to trial. So you've got 30 defendants, journalists, editors, but most notably you have Rebecca Brooks and Andy Coulson, and they're the two most high-profile people.
And what are the charges?
So there are a few conspiracy charges. The main is conspiracy to intercept communications, phone hacking, and also email, as well as conspiracy to commit misconduct. That's because some of these defendants were bribing government officials, police officers, corrections officers, anything to get information. That was that conspiracy. And then Brooks and her husband and a few others, they're also being charged with conspiracy for removing the computers and documents. I mean, they were taking things out and destroying them. And this just... I think it's so compelling, this case, because it reminds all of us about how the British media were targeted, and rightfully so, after Princess Diana. So this is not something that's new, right? And for lack of a better term, the British paparazzi, they're out of control. And this is finally, it's gotten to this point where it's legally impermissible.
At a time, but will this outcome, the outcome of this case, have a reasonable or an appreciable effect on Rupert Murdoch?
Well, At the time, I think in 2011 or soon after, when these charges surfaced, he had to sell his 168-year-old newspaper. So imagine if that happened here or in any country, frankly. It's such a jarring thing for this mogul, right? Mm-hmm. And since then, he's also suffered. He's spent millions in settlements, and he had to divide News Corp into 2 divisions. So he suffered so much. I can't imagine what more could be done, but clearly there's a chink in the armor.
Mm-hmm. Indeed. Well, no, we'll keep our eye on that as well. Seema Iyer, as always, thank you.
Thanks.
Okay, see you soon.